Hello, my name is Ann Pham. I am a student at Southern Utah University's Master of Accounting program. Today we'll go over a Giving Voices to Values case called Franklin Industries Whistleblowing, where we explore whistleblower rights. We will go over the case description, the definition of whistleblowing, what values are being challenged, the arguments about why you should whistleblow, and your rights as a whistleblower. Natalie Garson is a CPA for Franklin Industries, a public company. A few months prior, she reported to her HR department about an accounting manager who Garson thought to have embezzled $5 million. After alerting the controller, she had been demoted from assistant manager to staff. HR determined there was an embezzlement and she has not been retaliated against. Garson sought advice from Roger Harris, who told Garson not to go against HR. He felt that alerting the CEO would go against the company's culture of don't rock the boat and would end badly for Garson. Garson still wants to report the case. Whistleblowing is the disclosure of an action that violates organizational norms or the law. When you're deciding whether to whistleblow, consider the following 5 factors. The level of harm the action can do to others, that whistleblowing is justified once the employer reports it to their supervisor and makes their more concerns known. If there's no action from the supervisor, they should go up the chain of command. The documented evidence exists and can convince a reasonable and impartial observer that your views are correct and there will be harm. And you reasonably believe that disclosure will create necessary change to protect the public and is worth the risk to you. The values we see in this case are integrity. When Garson reported the embezzlement, she showed others that she was someone they could trust to have their best interest. If Garson decides to escalate the issue to an outside party, she'll display that she has the courage to protect the others at the expense of herself. Professionally, Garson upheld her reputation as an honest CPA when she reported the embezzlement, and that she practiced due diligence when she reported the action to the higher-ups, showing that she adhered to the ethics code as required of the CPA. And in order to persuade others, you'll have to see what their arguments are and what's in it for them. Garson should consider addressing the rationale of not rocking the boats. At stake for Garson is her integrity, reputation, and pride. At Harris, his reputation as a trusted CPA. And the CEO, a deficit of $5 million from the company's budget and potentially losing investors. For them to see her views, she could tell HR that she'll go to the CEO and that the severity of the embezzlement will make the CEO scrutinize HR's proceedings. She can tell Harris that while he's loyal to the company, that means doing what's best for the company, which could be alerting others of the embezzlement. She could also appeal to his commitment to the AICPA Code of Conduct. If the board rejects her case, she could emphasize how $5 million will affect the company's earnings statement and affect how investors make their decisions. Lastly, for whistleblowing rights, they are protected under Sarbanes-Oxley Act, known as SOX, and Dodd-Frank Act. Under SOX, Garson would be able to report within 180 days of when she first became aware of the fraud. And under Dodd-Frank, she is also protected against retaliation and will be able to receive a reward of 10 to 30% of the collection of monetary sanctions. But under Dodd-Frank, she must have alerted responsible management who, after knowing what happened, has not taken actions to correct the fraud, and she has waited 120 days before reporting to the SEC.